Okay, should I avoid a due diligence by giving extensive warranties? The base of this question is that as a startup, you are desperate for that money, and due diligence could take some time, weeks, months. So startup may say, let's ignore all of that. Let's just get the money now, and I give you warranties. What are warranties? Warranties are a statement of confirmation as to the state of affairs of the company. Right? I confirm I don't have litigation proceedings. I confirm I have these contracts. I confirm I have these assets. These are factual confirmations, and if there is an inconsistency with it, then the investor can sue you for that inconsistency. So that essentially you're telling them, hey, my company is in good health. If anything is wrong, just sue me. I would say that generally investors will want to investigate into the affairs of the company. I think just getting pure warranties on its own is not sufficient. I don't think any investor will just ignore this requirement. And it can be very painful because they will go there with very, very inquisitive eyes. They'll be the Sherlock Holmes, right? So if they ask you for a lot of information, very sensitive stuff, it's normal. They will want to know everything about your company.
Yeah, so as Jo Yan has mentioned, warranties are quite important for a VC because they come into a company that have not run. And generally speaking, under I think Malaysian law as well, there's this caveat emptor rule. So, buyer beware. There's no duty to disclose problems with your company compared to some countries like maybe France, where they have a duty of good faith. So they serve a function to sort of make you disclose stuff that you may not want to disclose. So investors use that to flesh out possible problem areas to start discussing, and also sometimes they use it to knock down the price because there's something about your company that they find out through the due diligence, or because they'll make you say, like Jo Yan mentioned, there are no litigation. So if there are litigation matters, you keep quiet. It's quite easy to find out. Then you've breached the warranty. So that they make you come out with it. And then they discuss what should we do about it. Should we go on with the deal? So it's to investors, it's a pretty big thing. Yeah.
So I think from a very practical perspective, yes, as much as you're desperate for that money, but it's also a good opportunity for you to lay your cards out so that, and these guys are experienced people, they know how to run companies, they know how to make your money, each ringgit count, or each Sing dollar count. So if they've identified a problem with it, they will let you know, hey, that's a problem for us, please go clean it up. You may not know what you don't know, right? I mean, so you get the professionals to identify the problems for you.
On this point, just one quick practical note. Quite often, a lot of startups don't have in-house IP or tech development, so they outsource it quite commonly. So sometimes they don't get the assignment of the IP because usually the developer would prepare the contract. A developer really just wants to be paid, right? So it's generally a very simple agreement that you will, the company will pay me X amount for this very vague kind of scope of work and specs, right? And then later when the VC comes in and asks, okay, this technology is pretty good, but do you own it? And you own it, but where's the proof? Where's the IP assignment? A lot of times it's not such an issue because you just ask the developer as your friend and I'll just sign it. But I've come across some not so scrupulous developers that hey, it's a good time to squeeze more. So generally I've never really heard of complete blackmail, but it does track the process. It's just one of those things that a VC will look for. Do you own your IP? Do you own your assets, like Jo Yan mentioned?
So what's the way to get around it? Before you engage the developer, do you get into some sort of a pre-assigned agreement or an IP agreement?
Yeah, I mean, I think the best time to ask for things is before you pay, right? Because then you're in control. After you've paid and then, what do you want? My time is money. Go ahead, yeah.
Well, generally speaking, an agreement is valid even though it is not stamped. It is only relevant if you want to adduce it as evidence in a court of law. So that's where you're going to fight. Okay? Generally, it's not very expensive to stamp agreements. It's just a nominal sum of 10 ringgit. Just an added hassle of just stamping it. But if you don't stamp it within the 30-day requirement from the date of execution, there will be a penalty when you do stamp it in future. But penalty against relative to, let's say, a 10 ringgit nominal sum is fairly small. So contract is valid even though it is not stamped. But you can't adduce it in court unless it becomes stamped.
Yeah. Sorry. Maybe we'll go after, yeah?
It's good to get the IP thing sorted out in the beginning. A lot of times we don't really know or don't really care. But what I read somewhere is that if I'm paying money to somebody to get work done, by default I own that work, unless specified that who owns it.
Exactly. What if they slip something in? So that's,
I mean, if something is mentioned, then yes. But if my contract doesn't talk about IP, I mean, is it true?
Actually, no.
Yeah.
That's the US position. Sorry, what's the question again?
Question is that if IP ownership is not specifically mentioned in the document, but by default something, if I pay somebody to build something for me, I own that. Sure.
Yeah, I think that's the value of having the contract, because the contract at least spells it out clearly in writing who owns the IP, despite payments and whatnot. And written evidence is always good comfort for an investor. They're not going to rely on some.
I understand that.
Yeah.
In general, by default, there should be something, right? I pay you, you do it. Like employee. Employee is working for me.
Sorry, if I may. I think it's probably similar in Malaysia, because we both got our IP laws from the Brits. The default position is the person who creates owns the IP, unless there is a written provision otherwise. So actually what you're talking about is the US position under, I think, a work for hire, if I'm not wrong. Employees, yes. Employees, because you pay them. So the law recognizes that what they create in the course of employment belongs to the company. Not so for contractors. Not so for contractors. I hope that clarifies.
But even in a contractual context, even from an employee perspective, if you're an employee who creates IP for the company, there's always some provision, contractual provision, just as a safety net. So it's not uncommon.
So I hope that answers the question. There's another gent at the back.
My question is, what is the common practice when it comes to IP ownership? The IP ownership to be owned by the new startup company or to be owned by the founder?
Well, from an investor perspective, it should be owned by the company. Right? So if they will seek all confirmation and implement all things necessary to ensure that the company can say, I own the rights.
In fact, from a from a co-founder perspective, you want that as well, because founders come and go, right? I mean, we know that plans change. You have a kid, you decide to go back to corporate. So if you don't sort it out, I don't think it will completely total or destroy the company. It's just troublesome when you get the Series A, and there's a whole checklist of documents they'll ask for. And so one of the founders, who was the guy who created the coder, he's left a couple of years ago. Maybe he went backpacking somewhere in South America, settled down, and it's hard to track him down. So these things, when you want to get Series A funding, sometimes the money, your burn rate is, and you want things to go fast, these things would delay the process.
Yeah. And also, like moving forward as a standalone asset, there can be valuation to the IP asset, and you can obtain funding because of that ownership. And the party that the bank will likely release the money to would be the company that operates the business, not the owner. So there could be practical reasons why you want to park the IP ownership with the operating company. Okay?
Well, you take that risk because when you outsource to foreign countries like Vietnam, Anyone from Vietnam here? So I say the right thing. But any cross-border kind of contract, there's always an enforcement risk. Do they have assets in Malaysia? Are you going to go to Vietnam and enforce? Probably not. But if you go to a quite reputable, and there are very good developers in Vietnam now. A lot of our startups in Singapore, I think they use Vietnamese dev houses. They will, they know what to do. So I think the moral of the story is, a contract is important, but make sure you get someone who is trustworthy, reputable. They will know what to do. But just be mindful of this.
Sorry.
Go on.
Back to the due diligence, like you advise on opinion to startups. What kind of documents to what extent? We can't really strict to all of them, but as like.
Okay. Well.
People even ask for everything. Should we just disclose? Because sometimes in terms of IP, in terms of our source code and so on and so forth. So should we just release to them and during the duty stage?
Do you want to?
Back to sorry, I missed out one point, which is sometimes developers don't own the IP. I mean, anyone who codes here, the repositories, they don't actually own, so they may not want to, or if you want to own it, they will have to charge you a lot more because they can't use it anymore technically. But at the early stage, the due D is not as extensive as say a Series E or a share acquisition, because most of the time, the first 2-3 years, what do they ask for? They ask for, do you own the shares? Can you show me some of your management accounts? I think it's fair to ask for management accounts. Hopefully you have them.
I think generally there are a few buckets that they will look at. They want to know what's the corporate structure, who are the shareholders.
Yeah.
They also want to know whether the shareholders have some sort of incentive scheme with the company, right? They also want to know whether the taxes are in order. That's assuming you're, revenue generating already. Contracts, what are the type of contracts you've entered into?
Yeah.
Whether there are any residual liabilities that could affect the company. What about things like liabilities, borrowings? Have you entered into any of those transactions of that nature? Assets, what assets do you own? Employment, contracts. So everything, they will want to know everything. But of course, because Series A is still quite, early relative to, let's say, Series E, the length of those documents will not be as much as Series E, because by Series E, the company would have been full-blown, all out, business as usual, boom, boom, boom. So, in short, I think they will ask for everything under the sun, but practically you may not have a lot to disclose.
So one practical tip is to actually prepare, get your house in order, so it's quicker. So due diligence will be very smooth, and you can get that out of the way and focus on the terms and the agreement, the shared agreement and the subscription agreement. It's quite standard actually. If you ask around, you Google, there's really a very standard checklist. Employment agreements, like and have there been shareholder loans given to and have there been very preferential terms given to the founders? They get paid 10K a month, even though the revenue is zero. Yeah. Things like that. Very fair. I mean, for the VC to want to know.
Yeah. The type of information you shouldn't be disclosing are those that are bound by confidentiality provisions. So if you have one contract which says this is a confidential contract, cannot disclose to anyone, then you might have to be restrictive on that now. Go get the consent of the other side before you disclose it to your investor. But then that could get into another problem, because maybe in your term sheet you say this transaction is confidential to begin with, then you're stuck. So then you have to find a practical way of disclosing it now. You could disclose the contract without disclosing the name of the contracting party. Right? There is a contract, but I'm not going to tell you who it's with.
Yep.
That could be
but you want to know the value and how long the contract is, and I'll blank out the name, but you get everything else.
Yeah. So Is it fair for an investor to prevent me from speaking to other potential investors? I think we've covered this point already. It does work in some startups' favor if they get competing offers. That way you get the best deal out there. Last bullet point, a bit of a trick question here. Do I still need my own lawyer even though I pay the legal costs of the investors' lawyers? Okay, so essentially I think we need to understand who does the lawyer act for, because the lawyer will act in the best interest of the client that they represent. Just because someone pays your fees, it doesn't mean that the lawyer represents you. So in this case, if the investor comes in, they will appoint their own lawyers who will act in the investor's best interest, but paid by the company. So the short answer is, if you are a startup, you should get independent legal advice. That means you have a second round of legal fees to pay, unfortunately.
Show of hands, do you know that in Series A, you pay for the investor's lawyer? A lot of people are shocked by this, actually. Why should I pay for the investor's lawyer? I'm paying this guy to advise someone against me. How come it's so unfair? Yeah.
Sorry to interrupt. The lawyers will start engaging with us even before the investment is signed up. So we will be only paying once the investment ends, and we won't pay in case investment breaks down halfway or something.
Depends on the terms of engagement with your lawyer. Yeah. But I think what we're alluding to is there are some founders who... Okay, who's watched the Facebook movie, Social Network, right?
Social Network.
Do you remember this scene where Zuckerberg signed some papers and he thinks that the company's lawyer is his lawyer? Does everyone remember that? So that's an example. He thought that the company's lawyer was acting for him, but it wasn't. It was the company's lawyer. So he signed away, I think, a lot of his rights, mistakenly thinking this is the guy who's partying, multi-billionaire, but he made this kind of mistake. So it could happen to anyone. And we just want to mention that although, you should get independent legal advice, it could be your friend, but don't think that the investor's lawyer is acting for you just because you pay for their fees.
Yeah.
Yep.